It's another Saturday, another car vlog, and another defamation lawsuit. This time Donald Trump versus CNN. Another defamation lawsuit. Viva Frei, Montreal litigator turned YouTuber, and if you've been watching my channel for long enough, you'll know that on the weekends I typically shoot vlogs in the car because it's the quietest place I can find in the house. Technically it's not really in the house, but it's the quietest place I can find. This Saturday is no different. I wake up to news of yet another defamation lawsuit, this time another Trump defamation lawsuit against another mainstream media outlet, this time CNN. At this point in time, I have done an excessive amount of vlogs on defamation. I did multiple vlogs and live streams on the Nicholas Sandmann versus Washington Post CNN defamation lawsuits. I did a vlog on the Tulsi Gabbard versus Hillary Clinton defamation lawsuit. I recently did a vlog on Donald Trump's defamation lawsuit against the New York Times. I dare say that I am becoming a defamation expert. So what do we have on the table today? Another defamation lawsuit, Donald Trump versus CNN for an article that is alleged to be defamatory. Now I'm going to link my defamation lawsuit playlist right up here so you can go familiarize yourself with defamation law, but I'll just go over the fundamental principles before getting into it. Defamation takes on two forms, libel and slander. Libel is literary written, slander is spoken. Defamation requires publication of a false statement that causes damage to the reputation about the person against whom it is spoken or written. It looks a little crazy when I do vlogs in the car to people who are passing the car. Truth is an absolute defense to defamation. In general, statements of opinion cannot be defamatory because insofar as they are statements of opinion, they can neither be proven true nor false. That being said, just prefacing what is otherwise a statement of fact with "in my opinion" is not necessarily going to be a valid defense to a defamation lawsuit. To the extent that the statement clearly is a statement of fact, cloaked as a statement of opinion, it can nonetheless be defamatory. And when it comes to defamation, you have a distinction that is to be made between public figures and private figures. When it comes to private figures, the threshold for defamation is lower, and when it comes to public figures, the threshold for defamation is higher. The threshold is in fact so much higher that when it comes to public figures, the statements that are allegedly defamatory have to have been made with actual malice. The criteria of actual malice being a pure construct of the Supreme Court of the United States as set out in New York Times versus Sullivan, 1964, I believe. But we will get back to that. And when it comes to public figures, you have your public figures by definition, rock stars, celebrities, politicians, and you have your limited purpose public figures. And that is to say, otherwise private citizens who become public figures on certain specific issues. Individuals who are thrust into the limelight because of accusations of particularly heinous crimes, individuals who might get caught up in highly publicized events even if it is not of their own choosing, individuals who decide to become spokespersons on specific political issues. And when it comes to limited purpose public figures, the same criteria applies to those individuals on those specific issues. All that being said, what is the specific issue now in Trump versus CNN? Trump is suing CNN for defamation on the basis of one specific article. The facts in Trump versus CNN are virtually identical, mutatis mutandis, to Trump versus the New York Times. CNN is alleged to have ran a defamatory article in that it contained false statements as relates to the Trump campaign. CNN knew or ought to have known that the statements in that article were false. CNN has a massive bias against Trump. They want to run negative news against Trump. They knew that the statements were false, and there is the actual malice. The situation is virtually identical to Trump versus the New York Times. I'm going to link that video right here if you haven't already seen it. It's virtually identical in substance from fact to law, with one small caveat as relates to the facts. This particular lawsuit invokes some of the undercover reporting done by Project Veritas as relates to CNN. So all that said, and given the similarities to Trump versus the New York Times, we're going to go through that lawsuit, but really only focus on the main allegations. We've got the parties: Donald J. Trump for President Inc. versus CNN Broadcasting Inc., CNN Productions Inc., CNN Interactive Group Inc. Jury trial demanded, and then we have the introduction and summary of the case. Defendants: CNN Broadcasting Inc., CNN Productions Inc., and CNN Interactive Group Inc., collectively CNN, published false and defamatory statements of and concerning the campaign, claiming that it, quote, assessed the potential risks and benefits of again seeking Russia's help in 2020 and has decided to leave that option on the table, end quote. At the time of publication, CNN was well aware that these statements were not true because there was an extensive record of statements from the campaign and the administration expressly disavowing any intention to seek Russian assistance. The campaign, through counsel, sent a written demand to CNN on February 25th, 2020 to retract and apologize for the aforementioned false and defamatory statements. CNN refused. CNN has engaged in a systematic pattern of bias against the campaign designed to maliciously interfere with and damage its reputation and ultimately cause the organization to fail. So again, it is the campaign that is the plaintiff and not Donald J. Trump personally, for the same reasons that I mentioned in Trump versus the New York Times. There are financial benefits to having the campaign be the plaintiff as opposed to any individual, although I suspect in Donald Trump's case, those financial considerations are all but irrelevant. The main reason why I suspect it's the campaign that is the plaintiff and not Donald J. Trump personally is for the purposes of avoiding deposition. depositions. To the extent that it's the campaign that is the plaintiff and not Donald J. Trump personally, Trump can, in theory, avoid depositions, or at least has a better argument to avoid depositions. If it ever gets to that point and CNN insists on deposing the plaintiff, in theory, the plaintiff can offer the most appropriate representative of the campaign, which need not necessarily be Donald Trump. In fact, I strongly suspect, and somebody correct me if I'm wrong, that even if CNN said, no, we want to depose Donald Trump personally, the plaintiff, the campaign, can say, no, he is not the best representative. We are giving you the best representative of the campaign for the purposes of depositions. Jurisdiction and venue. This court has subject matter jurisdiction over this action under 28 U.S.C. sections 1332A1 because the campaign resides in the state of New York and CNN resides in the state of Georgia and Delaware. Additionally, the amount in controversy is in the millions of dollars, which exceeds statutory minimum of $75,000. Venue is proper in this district under 28 U.S.C. sections 1391B1 and B2 because CNN is located in this district and published the defamatory statements alleged herein within this district. And they are suing in the United States District Court for the Northern District of Georgia, Atlanta Division. Now, under Canadian law, and from what I understand is relatively the same under U.S. law, when picking a jurisdiction, there has to be some nexus between the jurisdiction and the lawsuit. Now, proper jurisdiction will vary depending on the nature of the action. It could be where the contract was signed. It could be where the damages occurred. It could be where the defendant resides. If the lawsuit relates to real property, proper jurisdiction could be where the property lies. And when it comes to defamation, proper jurisdiction can be where the defamatory articles were published. All that to say, and setting aside any potential legal battles over proper jurisdiction if the party so choose to raise them, the Trump campaign has chosen Atlanta, Georgia as the proper jurisdiction, which is probably a better venue than, say, New York or California. Statement of facts. On or about June 13, 2019, CNN published an article on the CNN website entitled, "Soliciting dirt on your opponents from a foreign government is a crime. Mueller should have charged Trump campaign officials with it," by Larry Noble. The defamatory article claims, among other things, that the campaign, quote, assessed the potential risks and benefits of again seeking Russia's help in 2020 and has decided to leave that option on the table. The defamatory article does not cite any facts or reasoning in support of this claim. The defamatory article is false. In fact, the campaign has repeatedly and openly disclaimed any intention to seek Russian involvement in the 2020 election. The examples of this are too numerous to fully enumerate, but examples include, and you can go on to read them yourself. Just to point out some interesting drafting here, the Trump campaign has alleged that they have disclaimed any intention to seek Russian involvement in the 2020 elections. And the 2020 qualification is key here because we all know some of the comments Trump made in 2016. And whether or not you took those comments seriously, whether or not you thought he was joking when he made them, he did nonetheless make them. And so you can appreciate that if Trump hadn't qualified that allegation with the 2020 timeframe, someone might have easily said that it's a false allegation. Details, but these are nonetheless the details that one has to consider when drafting. You do not want to draft an allegation to make it easy for someone to prove wrong. The statement that the campaign has, quote, decided to leave the option on the table, end quote, of seeking Russian assistance was made up out of whole cloth. And if you're anything like me, you have not heard that expression out of whole cloth before, and you're wondering what its origins were, and here they are. Out of whole cloth is an American idiom that entered the English language in the early 1800s. Out of whole cloth describes something that is untrue and has no grounding in the facts. The expression is generally used in the phrases made out of whole cloth, make out of whole cloth, makes out of whole cloth, making out of whole cloth. Whole cloth is a piece of fabric that has not been cut into pieces. The literal meaning of the term whole cloth goes back to the 1400s, but the idiomatic expression pertaining to whole cloth first appeared in America in the early 1800s. The idea behind the meaning of the phrase out of whole cloth is that a lie is a completely new fabrication, as is a piece of whole cloth.
That's very interesting, actually.
But here is where the allegations get juicy. It is not entirely surprising that CNN would publish such blatantly false statements about the campaign. There is extensive evidence that CNN and its writer, Larry Noble, are extremely biased against the campaign. This evidence includes, among other things, undercover video footage taken by the Project Veritas news organization in which CNN staff members admit on camera that CNN's coverage is extremely biased against the campaign, the administration, and Republicans in general. In the Project Veritas footage, Nick Neville, a media coordinator at CNN, admits that CNN's chief executive, Jeff Zucker, has a personal vendetta against the president. John Bonifield, a supervising producer at CNN, states in the Project Veritas footage that CNN's coverage regarding Russia's alleged interference with the 2016 election was, quote, mostly bullshit, and that the president, quote, is probably right to say, you are witch hunting me. Christian Sierra, a media coordinator at CNN, states in the Project Veritas footage that Mr. Zucker wanted impeachment to be the top story every day. That, quote, everyone at the network, quote, complains about the amount of such coverage, and that CNN's, quote, Democratic interviews are like softballs compared to the Republicans. Carrie Porch, a CNN employee in the Washington, D.C. bureau, states in the Project Veritas footage that CNN, quote, purports to be facts first, and that's clearly not the case. The news stories at www.cnn.com follow the same extremely biased news perspective. According to a recent reliable survey, 93% of all stories at www.cnn.com were aggressively negative about the current president, whereas coverage of past presidents was only around 50% negative. Larry Noble, the author of the defamatory article, has a record of malice and bias against the president as well. On February 14, 2020, Mr. Noble tweeted, "Trump cheats and lies, and when caught, lies again and claims the right to make the rules. He claims defeats as victories, takes credit for anyone's success, and blames his failures on others. And the Republicans have told him they are fine with that, so he's just getting started." Mr. Noble has written numerous articles accusing the president of criminal activity and of campaign finance and ethics violations, and has lodged a complaint against a super PAC which supports the president. So those are the most essential allegations of the lawsuit. There's nothing rocket sciencey to this. It is a straight up defamation lawsuit. The allegations are to the effect that the article made statements of fact which are demonstrably false. They damage the reputation of the campaign. CNN has an active bias against the president, which is why they publish these defamatory articles, hence the actual malice, or at the very least the reckless disregard of CNN. Larry Noble, the author of the impugned article, has a history of bias and animosity towards the president and Republicans in general. The undercover footage obtained by Project Veritas is at the very least going to be relevant evidence to show the underlying malice coursing through the veins of CNN and Jeff Zucker. And that in turn is going to substantiate the claims of actual malice that is required in order to succeed on a defamation claim against a public figure, which the campaign concedes it is. Now, one peculiarity of this lawsuit, which incidentally is the same peculiarity I noted in the Trump versus New York Times lawsuit, is that they do not mention that the impugned article was in the opinion section. They don't mention that the article is an op-ed. They don't get ahead of the ball on this one in terms of anticipating what they know is going to be an argument from CNN. Opinion being a defense to defamation, you know that CNN is going to raise the argument that this was just an op-ed, this was just Noble's opinion, and therefore it's not a statement of fact and therefore cannot be defamatory. If I'm the Trump campaign's lawyers, I am getting ahead of that argument and I'm going to make it for them and undermine it for them before they can make it. I would anticipate this argument and I would make allegations to the effect that notwithstanding that this is passed off as an opinion piece, that it's published in the op-ed, this is not opinion, these are making statements of fact. The author of the article is making overt accusations of criminal activity, and that is defamatory. Now, when I made these observations in my last video of Trump versus the New York Times, a lot of people were saying, this is not about winning the lawsuit, it's about getting to discovery. That's all fine and well, but a lawsuit nonetheless has to be sufficiently well drafted to get to discovery. Remember, in the Washington Post lawsuit, we saw the Washington Post succeed on a motion to dismiss before depositions. Admittedly, the judge reviewed his initial dismissal and allowed the claim in part so that they will proceed to depositions, but a lawsuit nonetheless has to be sufficiently well drafted to survive a motion to dismiss to get to discoveries. In chess, you can sacrifice a piece, you can make a gambit, but it has to have some longer term goal. Just giving up a pawn for the sake of it is not a strategy. I would have been ahead of the ball and I would still amend both of these proceedings to address those arguments, because those arguments are coming sooner than later, probably sooner and probably by way of motion to dismiss. Now, as relates to the criteria of actual malice, and this is something I did say in the Trump versus the New York Times vlog as well, Clarence Thomas has publicly stated that he believes it is time to review and possibly set aside the principle set out in New York Times. So let's talk about that very briefly. The criteria of actual malice in order to succeed on a defamation claim against a public figure was a pure construct of the court. And just a brief summary of the New York Times versus Sullivan so you have an idea of the context. The case began in 1960 when the New York Times published a full-page advertisement by supporters of Martin Luther King that criticized the police in Montgomery, Alabama for their mistreatment of civil rights protesters. However, the ad had several factual inconsistencies, such as the number of times King had been arrested during the protests, what song the protesters had sung, and whether or not students had been expelled for participating. In response, Montgomery Police Commissioner L.B. Sullivan sued the Times in the local county court for defamation. The judge ruled the advertisement's inaccuracies were defamatory per se, and the jury returned a verdict in favor of Sullivan and awarded him $500,000 in damages. It then appealed to the U.S. Supreme Court, which agreed to hear the case and ordered certiorari. In March 1964, the court issued a unanimous 9-0 decision holding that the Alabama court's verdict violated the First Amendment. The decision defended free reporting of the civil rights campaigns in the southern United States. It is one of the key decisions supporting the freedom of the press. Before this decision, there were nearly $300 million in libel actions from the southern states outstanding against news organizations as part of a focused effort by southern officials to use defamation lawsuits as a means of preventing critical coverage of civil rights issues in out-of-state publications. The Supreme Court's decision and its adoption of the actual malice standard reduced the financial exposure from potential defamation claims and thus frustrated the efforts of public officials to use these claims to suppress political criticism. Now, yes, I am citing from Wikipedia here, so take that summary with the requisite degree of skepticism. But all in all, it's a pretty accurate summary, and one can see how the New York Times versus Sullivan Supreme Court decision was sort of a policy decision. It was, at the very least, a highly political decision. Some might argue that it has expanded the freedom of the press to the point where the press can publish whatever the heck they want, with no fear of repercussions, even if it means destroying the life of a 16-year-old kid. And it's in today's context that Clarence Thomas has said it might be time to revisit that principle. Freedom of the press is entirely one thing, but a press that has totally run amok with absolutely no repercussions is entirely another. And I don't think you have to have a particularly creative imagination to appreciate that this might be the underlying principle of what Donald Trump is doing via these lawsuits. And above and beyond calling out the press on what Trump feels to be their total fake news coverage, I have no doubt that is also one of the objectives of these lawsuits. We'll see if we get there, but the lawsuits still need to be properly drafted to survive motions to dismiss, so I would highly recommend those amendments if anybody is listening to this video. And that is today's vlog. If you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below. If you want to support the channel, there are merch links, Patreon, Subscribe Star, PayPal options in the pinned comment. I started a podcast. It is called Viva Law Podcast. Check it out and subscribe. And if nothing else, share my stuff on social media if you are so inclined. It helps my channel grow, and I greatly appreciate it. And now you know your vlog. Peace out. Booyah!